they could be sentenced consecutively. So for instance, just as an example, if I gave you 6 months on one and 6 months on the other, you'd have to serve a full year. Two files here, 26-3663 and 3675 FH. Appearances, please.
Thank you very much, Your Honor. Attorney Robert Rincham, Assistant Prosecutor from Stockton County.
Robert heard himself and Mr. Cole was going to my lecture.
All right, thank you, gentlemen. Also, this one is Miss Laura O'Dell. She's agent from the Michigan Department of Corrections. We're here today for a probation violation hearing. I think we're actually set for an informal, having there just been recently an arraignment. Looks like that arraignment was done back on April 30th. Mr. Hartel, what are we doing today?
Yes, Your Honor. I believe we reached a global resolution for that and the underlying pretrial as well. I shouldn't say underlying, but also the pretrial in his other cases.
Okay, hold on. Oh, that's right. So 3675 is the pretrial, and then 3663 is the probation violation.
That's correct.
May I approach?
Okay, thank you.
I did turn in advice of rights on Friday.
Okay, thank you very much. All right. And is there, for the probation violation, is there going to be, is it just a plea to the two that I see in the new charges?
Yes, Your Honor.
Okay, got it. So there are actually, it's quite a few, like 13 counts, but he's going to plead guilty to 2 of them.
Well, the offer would be him pleading to no contest, Your Honor. That being said, I guess there's potential civil liability, but he also indicates that he was not necessarily in his right mind that day and does not remember everything that there is to it.
I do see that count 1 of the probation violation alleges that he failed to take medication as required at the jail for his own mental health treatment. All right, that makes sense. Mr. Hartel, is that a complete and accurate statement of the probation violation and the new charge?
It is, Your Honor.
All right. Now, I don't know which ones we want to choose. Maybe just choose counts 1 and 2 on the new case. Is that right?
That is what we had decided on, Your Honor, and the police report is up there in March.
All right. So that means on the probation violation allegations, it's going to be counts 7 and 8. All right. Copy.
Yes.
Thank you. All right. Mr. Ringstrom, anything further to add before I turn to the client and the defendant?
No, Your Honor.
All right, thank you. Oh, wait, I see you guys. No, disregard. I got it. All right, Mr. Cole, have you heard what the attorneys and I have just discussed?
Yes, Your Honor.
Is that how you wish to resolve the files today?
Yes, Your Honor.
To the best that you can, please raise your right hand for me.
Yes.
Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Thank you. We're going to take just a moment. I see some confusion over there. Maybe, maybe not.
Yeah, I didn't know if you wanted the bench warrant counts to correspond deputy-wise with the...
I thought I did. We've got for counts 1 and 2, we've got Deputy Seiler and Deputy Booms. Deputy Seiler is count 8 and Deputy Booms is count 7.
The issue that we're having, Your Honor, is that it was 3 different officers involved twice, but I think that the court would have it right.
I got it. I got it. All right. Thank you very much. I guess I could have done 5. We're just going to do 7 and 8.
Okay.
All right. Thank you. All right, Mr. Cole, you've got a couple cases going on, and we're going to talk about them. Now, there's a new file, and I'm going to talk about that one first. Now, in this new case, you are charged with six counts of assault, resist, obstruct a police officer. And each one of those is a felony punishable by up to 2 years and or up to $2,000. Now, what I need to know here from council is, did this occur within a confinement facility?
Yes, Your Honor, it did.
Okay. And do the people intend to request consecutive sentencing even though it's within the discretion of the court?
People do not intend to request it.
Thank you. So of those 6 counts, again, if you were found guilty or pled guilty to 2 or more, or if you pled no contest, they could be sentenced consecutively. So for instance, just as an example, if I gave you 6 months on one and 6 months on the other, you'd have to serve a full year. But I'm told that the people are not requesting consecutive sentencing. And I don't intend to issue consecutive sentencing. Do you understand?
Yes, Your Honor.
Now, I'm told today that you're going to enter a plea of no contest to 2 of those counts. And we're going to go with count 1 and count 2. And then if you enter a plea of no contest and I accept that plea, the other counts will be dismissed. Does that make sense? All right. Now, I have here a thing called a pre-trial agreement, which was handed to me by counsel. And I'm holding it up here, and it has 2 pages. All right. Now, I see your signature, or at least it appears to be your signature on page 2. Is that your signature?
Yes, Your Honor.
Now, did you read through when this pre-trial agreement, which is only 2 pages, but did you read through it before you placed your signature on it?
Yes, Your Honor.
And did you talk to Mr. Hartel?
Yes, Your Honor.
And was he available for you and answer any questions that you had and talk to you about the evidence and police reports and things like that?
Yes, Your Honor.
And did he go over with you your options?
Yes, Your Honor.
And are you satisfied with his advice as of today?
Yes, Your Honor.
Thank you. So again, I'll note here that this written pretrial agreement provided to me by the parties is consistent with the pretrial agreement as we discussed, except for I forgot one thing. There was also on the felony information a sentencing enhancement called a habitual offender second. Now, habitual offender second can increase the maximum punishment for a felony, in this instance, from up to 2 years to up to 3 years. However, that is also going to be dismissed. Do you understand that?
Yes, Your Honor.
Okay, great. I'll also note here that we have a pretrial agreement report that also appears to have signatures from the council party. So I'll put that over here. Now, by entering a plea of no contest, it has the same impact as a guilty plea. The difference is instead of requiring you to recite a factual basis, I'm going to look at something such as a police report to make a determination. Now, it's really important to understand that if you plead no contest and I look at this report that the parties have provided to me, you can't come back and say that anything in here is untrue. You understand that?
Yes, Your Honor.
Okay. And also, I get to accept a no contest plea in only a couple ways. And one of them is when there's a lack of memory. And that could be due to mental health issues, lack of medication, or even taking medication and being intoxicated. But again, I can take a no contest plea based upon what the council have told me. Do you understand that?
Yes, Your Honor.
Now, before I talk about what you're going to ask you for your plea, I need to go over certain rights. Now, if you enter a plea of no contest in this new file, you'll no longer have a trial. You'll be given up the right to be tried by a jury, the right to be tried without a jury, if you chose, the court, the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have its silence used against you, and the right to testify if you chose to testify. Mr. Cole, do you understand those rights?
Yes, Your Honor.
And again, even more importantly, do you understand that if you enter a plea of no contest, you will be waiving those rights as they apply to this particular case?
Yes, Your Honor.
Also, based upon the plea, any appeal will be done by filing of what's called an application for leave to appeal and not an automatic or claim to appeal by right, which is only guaranteed when someone is convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also would be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Mr. Cole, other than the terms of the agreement that we've gone over, have there been any other promises, threats, or inducements to force or coerce you to plead guilty that we haven't talked about today?
No, Your Honor.
Are you therefore entering the plea of your own free choice?
Yes, Your Honor.
Now, Mr. Hartel has probably talked to you about potential sentencing, maybe the sentencing guidelines, and try to give an idea as to what he thinks the court may sentence you to. The question I have, however, is, has he or anyone promised you, suggested to you, or led you to believe what an exact sentence would be?
No, Your Honor.
Okay. Now, if you enter a plea today to the counts 1 and 2, we now need to talk about the other file for which there's a probation violation. In that particular file, there are 13 counts of alleged probation violations. You were placed on probation by this court on April 7th of this year. The court takes judicial notice of the terms and conditions of probation that were signed by me on April 7th, and apparently refused by you on April 10th, but witnessed by another agent of the court of the Sheriff's Department. Also, in that request and warrant for probation violation dated April 28th of this year, again, there were 13 counts. Now there, as we were mentioned, as you were informed earlier and previously, you have the right to challenge those 13 counts at a contested hearing and have the prosecutor prove them by a preponderance of the evidence, which is a lower standard of proof compared to that of proof beyond a reasonable doubt. You also would have the right to be represented by your attorney at that hearing, the right to question and cross-examine any witnesses presented against you, which presumably would be the same witnesses in the new file, the right to present witnesses to evidence or testimony, and the right to remain silent and not have that silence used against you. Now, if you're found guilty of, and I'm told today that you're going to plead no contest, to counts 7 and 8, which have to do with the same deputies that are involved in counts 1 and 2 on the new file. Now, if you do, and the court accepts that plea, the other 11 counts will be dismissed, and you'll be resentenced on your original offense. In that case, you were convicted of domestic violence as a third offense, which is a felony punishable by up to 5 years and up to $5,000 in fines plus costs. Do you understand?
Yes, Your Honor.
And again, the court would be taking a look at presumably the same exhibit to support the no contest plea in both files. Do you understand?
Yes, Your Honor.
All right. Therefore, and I'm going to remind you before I go into taking your plea, I anticipate your plea to be no contest. I'm not telling you what to say. I'm just telling you that's what I anticipate. The reason why I caution you is because I caution everybody when they do a no contest plea, because some people just blurt out the word guilty. So we don't want to do that. We want to respect your right to enter the no contest plea. In file 3675, as to counts 1 and 2 of assault resist obstructive police officer in the performance of his duties, how do you plead?
No contest, Your Honor.
Thank you. In file 3663, which is the probation violation allegations, as to counts 6 and 7, how do you plead?
No contest.
Thank you. All right. The court has received what is now marked as People's Exhibit number 1 from the prosecutor's office. It is a Missaukee County Sheriff's Incident Report 26-794-157. It consists of 5 pages. Mr. Ringstrom, are you asking the court to accept People's Exhibit number 1 for the taking of the pleas in both files and for sentencing?
I am, Your Honor.
Mr. Hartel, any objection?
None, Your Honor.
Thank you. People's Proposed Exhibit number 1 is hereby admitted. One moment. All right, the court first notes that there is a date which is consistent with the dates alleged in the probation violation and the new felony information of events occurring on or about April 21st of this year here in Missaukee County in Lake City. One moment. Note specifically in People's Exhibit number 1, there is a thorough description of the events on that day. Specifically, they focus there a lot about the involvement of or acts upon Deputy Boones, who is a Missaukee County Sheriff Deputy, and the performance of his duties. And then subsequently, in the affidavit attached to the request for a complaint, there's further information discussing the involvement of Deputy Seiler, who the court notes is a deputy with the Missaukee County Sheriff's Department. The court also notes that it occurred in the Missaukee County Jail. I only make that note, even though, again, I've already said that I don't intend to find a sentencing defendant to the consecutive sentencing. Mr. Ringstrom, do you believe the interests of justice do not require the recitation of facts to support the plea?
I do, based off of the other probation violations.
Thank you. Mr. Hartel?
I also agree.
Mr. Ringstrom, do you believe that People's Exhibit number 1 supports all the factual elements required for counts 1 and 2 in the new felony information and counts 7 and 8 in the probation violation?
I do, Your Honor.
Mr. Hartel, do you agree?
I agree, Your Honor.
Mr. Ringstrom, are you aware of any other promises, threats, or inducements?
There is none, Your Honor.
And do you believe I comply with Michigan Code 6.302 and 6.445?
I do.
Mr. Ringstrom, do you agree with both?
Also agree, Your Honor.
All right, good enough. Thank you. The court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. The court finds specifically that the interests of justice do not require the recitation of facts. Not only could there be potential civil liability, but also based upon the other information about mental health and status at the time when the events occurred. Therefore, the defendant is found guilty in file 3675 of counts 1 and 2. The remaining counts and the enhancement will be dismissed at the time of sentencing. In file 3663, the court finds the defendant guilty of counts 7 and 8 on the request and warrant for the probation violation, and the remaining 11 counts are hereby dismissed. All right, we can probably set this for sentencing jointly together, Ms. Odell. Do you agree?
I agree, Your Honor.
Mr. Ringstrom?
I agree, Your Honor.
Mr. Hartel?
I agree and would appreciate that so that he can get as much credit as possible.
That's why I agree as well. All right, good enough. Mr. Cole, we're going to set this out for sentencing, and it'll probably be in about 4 weeks. Now, between now and then, even though you had a prior pre-sentence investigation report prepared, we're going to do an update to that and have you fill out another PSI packet. You'll be subject to another interview with Miss Odell or someone from her office. And you have the right to have Mr. Hartel present. Also, Mr. Hartel will meet with you prior to coming back for sentencing to go over that. Each side has the right to make objections or request corrections to the report at the time of sentencing. Okay. Anything else, Miss Odell?
I don't think so, Your Honor. Thank you.
Mr. Ringstrom?
Not for today, Your Honor.
And Mr. Hartel?
Nope.
All right. The court revokes any bond that might be out there. I don't think there is any. Remands him to the custody of the Missaukee County Jail. Is he still serving his original sentence?
Yes, Your Honor.
What I thought. So, yeah, he's not going to get any. Well, anyways, we'll see how it all works out. Mr. Cole, I know today I want to highlight for you, if there's any mental health treatment that you need, or they're able to provide for you, or they are providing, I strongly encourage you to participate, because we want to make sure that you are receiving any treatment that you need. Thank you, folks. We are adjourned. Mr. Ringstrom, your police report as ordered, and that was for community corrections, and they had been unable to verify her attendance at the Bear River treatment program in which she was to participate. Ms. Hall was then lodged in Kalkaska County on a warrant dated, I'm sorry, I don't know if the warrant was, or that's when she was arrested on March 13th of this year. All right, thank you very much. I should have counted. Also that on April 21st, 2026, Judge Corey Wiggins of the 84th District Court, operating by a state court administrator's order to allow him to appear and cover my docket while I was out of town, conducted an arraignment. And that's why we're here today. All right, Mr. Champion.
Your Honor, at the time of the arraignment, we did not have verification that Ms. Hall has completed her inpatient portion of the Great Lakes Recovery Center. Since then, or shortly, I think it was the very next day or that day, we did receive verification that she had completed on the program at New Hope House in Petoskey, and she had transitioned into the outpatient portion of the treatment program. However, when she did that, she did not sign up for the testing as required by her bond violations. Ms. Hall is aware of that and will be admitting responsibility for that.
All right. This court back on January 5th of this year signed an order releasing Ms. Hall on a PR bond to an inpatient treatment program. That was to begin on January 8th. That was the Women's New Hope House Residential Treatment Facility up in Sault Ste. Marie, which also has offices in, I believe, in Petoskey. And then upon release, she was to report to community corrections. All right, Ms. Hall, please raise your hand to the best that you can. Let's switch hands. It's okay, everybody does it. You swear or affirm the information, testimony you're about to provide shall be the truth, the whole truth, nothing but the truth, ma'am?
Yes.
Thank you. All right, Ms. Hall, you do have the right to due process, which requires the court to, requires the prosecutor to produce some evidence to demonstrate that you had violated your bond. And that could be through a hearing. Now, that's not a trial. It's not proof beyond a reasonable doubt. And if you make an admission today, you won't have that hearing. Do you understand?
Yes.
And has anyone made any promises, threats, or inducements to force or compel you to admit to violating your bond today?
No.
All right, thank you. Is it true, Ms. Hall, that upon being released from the New Hope program, you failed to report to community corrections?
It is true, but I didn't understand that that's while I was still in treatment.
Mhm.
That's what I didn't understand that I had to do that then.
Okay. And so when did you get out of, was there a residential portion?
Yes.
And when did you get out of the residential portion?
I was there for 2 weeks.
And when you went there and got out in 2 weeks, had you successfully completed the program?
Yes.
And when you got out, where did you go?
I went to my address at 802 Fire Street.
Okay. And was there any outpatient or sober living program that was attached to the New Hope treatment?
I don't believe so.
Okay. All right. The court finds the defendant has violated her bond, specifically paragraph 7 on page 2 of the court's order dated January 5th of this year said, upon planned or actual departure from the treatment facility for any reason, the defendant and or the facility shall immediately notify community corrections and the public defender program. Also, is to comply with all other bond conditions. All right, so therefore the defendant is in violation of her bond. Have we already, she's awaiting sentencing but had pled.
She has blood, correct?
Yeah. Okay. So is she also being held, from what I understand, on this other case up in Kalkaska? What's happened with that now?
That was a fines and cost situation, and that has been resolved, Your Honor.
All right. Thank you. No, because today is set for a bond hearing. I don't have a PSI here in front of me today. Is there anything we want to proceed with sentencing? I'm sure I could get a PSI.
We have no objection if the court wanted to do. We have the copy of the PSI.
Miss Odell, do you have a copy I could review, or somebody? And Mr. Ringstrom, any objection to proceeding with sentencing?
I do not, Your Honor. For the record, on February 27th, we had gone through the PSI as a whole.
Yeah.
We were about ready to sentence. I only have my copy, but
Okay. All right. I've got that. Miss Odell, are you gonna, well, it looks like Mr. Blazak is the one that signed it. Is he here today? Sorry?
Are there questions, Your Honor?
I don't know. Well, we're gonna need to change the sentencing date, little things like that. But, all right, thank you. So I'm gonna take a quick look here at the PSI. We're gonna obviously turn to CFJ 145, page 1. The court is going to, we need to change the sentencing date. We at one time, we're gonna be here for February 27th. We adjourn that to allow Paul to continue doing any kind of treatment. So change that date. Now, there was no pretrial credit. I forget, was she on a parole? Or why was there?
No, I wasn't.
Wait a minute.
I waived my plan.
Yeah, so she would have been in jail for at least almost 2 months. So it looks like we need to calculate some credit there. Was she serving another sentence or anything?
I gotta just look.
I don't see anything here in the court file that suggests that she wouldn't. Can you help us out at all? Do you see anything else from Ms. Hall?
As far as,
Was she serving a other sentence? Saying yes. Well, let's take a look at the criminal history here. So she had a case in which she was arrested on September 9th, 2025. We're here for the case for an event that occurred on July 25th of
Yes,
2025.
Right. Your Honor, she had a case in Wexford County at that
Yeah,
point.
she had 60 days of jail.
Correct.
I see that. All right. So that makes sense. All right, so we don't need to make any change there. All right, since we went over the PSI before, I don't think there's any need for correction. Mr. Brinkster, do you feel any need to raise objections or concerns?
I don't, Your Honor. I guess I would just be curious as far as the time that she has just recently served. If she was credit for that.
I want to make sure that we have on her substance abuse treatment on CFJ 284, page 20. Put in there some recognition that she just participated in a program in 2026, January, up at Woman's New Hope. I see Ms. Odell shaking her head. And
Agent Blazak is on his way.
oh, okay. All right. Anything else that needs to be updated, Mr. Champion?
Not that we haven't discussed, Your Honor.
Okay, great. Thank you. All right. So now we're going to move to allocution, Mr. Champion.
Your Honor, so the court's aware my client did complete the inpatient treatment at New Hope. She was discharged. The letter that was sent to the parties is that she did well in the program and was doing well in the outpatient portion. She did return to Cadillac to care for her mother, who now has care. Since she's been incarcerated, she has continued her recovery with community mental health. She's met with them several times. With that, Your Honor, she also has a job waiting for her. When she has completed any term this court may deem appropriate. So the court's also aware when she was taken into custody, she did not test positive for any controlled substance, and she's quite proud of the fact that she has remained drug-free in this matter.
That reminds me, Mr. Champion, when did she get picked up? I got to give her credit. I'm sorry. We need to give her credit for that.
That's where it gets a little, she would have been picked up, I believe, in Kalkaska on March 12th. The warrant in this case was then issued on the 21st or thereabouts in March.
Yeah, I signed it on March 25th. So I think at the very least, Mr. Blazak has now joined us. Mr. Blazak will have made a couple of changes. Ms. Odell was nobody knows. One was the date of the sentence. One was adding her time on the CFJ 284 section for her recent treatment at Women's Health. And I now realize we need to give her some credit on CFJ 145, page 2. The court issued a bench warrant on March 25th. It says she wasn't taken into custody until April 21st. But she already I had a bench warrant and she got picked up on March 12th or 13th.
Correct.
So we're going to err on the side of conservativeness and say that she may not have been transferred, but she may have continued to be held on our warrant up in Kalkaska. So we need to do some math.
It'll be 53 days credit.
I'm getting 52 days.
It is 53. Your Honor.
53. Oh, I'm sorry. Yes, because of March having 31. Thank you. However, that doesn't count today because she already gets credit for today. So is that 52 days, Ms. Odell?
It's 53.
53? All right.
Not counting today.
Okay, good. So Mr. Boyes, it's going to add on that page in the PSI that there is a total of 53 days of credit, which of course will also appear on CFJ 145, page 1. All right, Mr. Champion, I'm sorry I interrupted you, but I didn't want to forget her credit.
You know, my client is very part of the fact that she has maintained her sobriety and she's learned skills to deal with her sobriety, I would ask the court to consider time served in this matter. And as part of probation, also have her complete the intensive outpatient treatment program.
All right, thank you very much. Mr. Ringstrom, I'm sorry. Allocution?
Your Honor, I mean, the guidelines are the guidelines in this case at this point in time. I will say for Ms. Hall, I mean, she didn't give prosecution any hard time. She owned up to what she did. Since that time, she has done rehab and all that. She's done a really good job, and this is her first drug offense. She's had a lot of thefts and stuff like that in the past.
That's quite a history.
The court's going to go through the criminal history and all that, but this is her first real drug offense as a whole. Guidelines are the guidelines. I would say, due to Ms. Hall's actions after being picked up and doing everything, if anyone deserves a little bit of a break, it would be her. I do agree with Mr. Champion that she would probably have to do some intensive treatment. We will leave it in the discretion of the judge.
I don't recall. Is she 7411 eligible?
I don't think she's 7411 eligible. I think that there was something to do originally we thought that she was 7411 eligible. In the PSI, I think they had mentioned something about some marijuana or something a long time ago that needed social work.
Yeah. Okay.
But originally we were going to offer 7411.
I see that. That was 2004.
Yes, correct. Our records did not show it at the time, but it came up at the sentencing.
Thank you. Ms. Hall, it's your opportunity to make a statement if you so choose. Is there anything you wish to say before I issue a sentence this morning?
Yes. I just wanted to say that I appreciate the opportunity to allow me to attend rehab. I took a lot from it, and it helped me with my guidance and my structure, and it's good to follow a routine in daily life. And I was very honest about my mistakes that I made, and I just really want to get over this and move forward in a positive way. That's it.
All right, thank you. Well, the sentencing guideline range here is a minimum of 5 to 23 months. While that is not mandatory upon the courts are required to take it into consideration. And it does help establish what may be a reasonable and proportionate sentence. The defendant's prior criminal history is extremely lengthy, and she's of an age where we hope that she should be learning better in her early to mid 40s. One thing that concerns me is, in addition to the number of juvenile and adult convictions, is that substances have been a significant part of her life. We can see that there has been some cocaine use for a long time, up to 26 years, methamphetamine for 23, LSD and their fentanyl, alcohol, and marijuana, although those stopped apparently quite a long time ago. But the more controlled hard substances have been an issue with her for half of her life. The court also notes that throughout her prior criminal history report, there are extensive crimes of dishonesty, retail fraud, breaking and entering, even driver license suspended is a level of dishonesty because it's doing what you know you're not supposed to do. There's a receiving and concealing property. She's had some issues with operating while intoxicated, breaking and entering into motor vehicles, even assaultive behavior a couple different times, a couple different retail frauds, violations of bond, again, violations of probation. And so it gives the court quite a bit of concern. Apparently she may have just gotten away with the substances and have not gotten caught. However, she has now participated in a program, and it appears to be, but it does appear to be her fifth inpatient program. She had one in 2024, another one in 2024, and then Great Lakes Recovery. So the court is at a bit of a loss what to do. I don't really know what to do. Got a significant benefit from the case of the prosecutors having dismissed the fourth habitual felon enhancement, which could have made this an up to life maximum, but we're now at an up to 10 maximum. It does, however, also benefit her on the guidelines. She's at a straddle cell. I don't need to come up with many or any reasons to be able to give her even a prison term. So the court is a little bit at a loss of what to do. I'm concerned also that she did not continue with her community corrections treatment when she was released from the program. I thought it was pretty clear. All right. The court places the defendant on a period of probation for 24 months. The court adopts the terms and conditions for that probation that are listed inside the PSI on pages CFJ 145, 2, and 3. The court finds those terms and conditions are well suited for rehabilitative purposes and for the facts in this case and the defendant's prior history of substance abuse. I'll also note that condition 3.3 not only requires potential mental health treatment, but also domestic violence if necessary, and that's consistent with her prior history. The court therefore assesses a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost, a $300 attorney fee, a $500 fine, no DNA fee as it was already available. There is a supervision fee of $30 a month or $60 a month if there is any electronic monitoring. The last thing for the court to assess is whether or not a jail sentence would be or is appropriate. And just on the criminal history alone, there's a significant reason to suggest that a period of confinement is appropriate. Also looking here at the guidelines, the court finds that one is appropriate. I will say, however, the court is not going to tip the scale to the prison sentence, obviously because of the probation that I've already announced. Therefore, the court sentences the defendant to a period of jail. And I'll say that I'm also taking into consideration that she did a program, and where I might have typically issued a 300-day jail sentence, the court goes 210 with 53 days of credit. If we're able to get her into a program, the court, of course, will consider an early release if that's recommended by the Department of Corrections. But as of right now, that's the sentence of the court. Mr. Champion, I have the pretrial of the advice. Do you have them already?
I do, Your Honor.
Thank you. All right. Mr. Rinkstrom, here's your copy of the PSI. Ms. Hall, Mr. Champion had you place your initials on a copy of the document, and then you're taking one copy with you. This document tells you that you have the right to appeal the conviction and sentence in your case. Now, while this is typically done by filing a claim of right to appeal, if there's been a conviction by a trial, based upon the plea, any appeal must be done by filing what's called an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Again, the court finds that its sentence today is reasonable and proportionate based upon the factors that I've discussed and those that are contained inside the PSI. Anything further, Mr. Blazak?
No, thank you, Your Honor.
Mr. Ringstrom?
No, Your Honor.
Mr. Champion?
No, no, thank you.
Ms. Hall, you've got, you're still young. 43 is, I think, the old 53 or 63. I don't know how to say that, but you got a lot of hard living. And I would like nothing better than to see you turn your life around.
A courtroom hearing took a serious turn as the judge reviewed Miss Hall's long criminal history. What started as a drug case quickly became an emotional sentencing hearing filled with discussions about addiction, probation violations, and years of substance abuse. The judge listed past crimes, failed probation terms, and a lifetime struggle with drugs like methamphetamine and fentanyl. Despite her completing rehab and staying sober, the court questioned whether she could truly change. Then came the harsh warning. The judge admitted she could have received a much longer jail sentence. In the end, Miss Hall was sentenced to probation and jail time with strict treatment conditions. Comment for the next part.
Always reach out to community corrections and always thank you. Mr. Blazak, I would like a part of our term of condition, recommend an EOP program through community corrections. If we could add that as well. I mean, I know it recommends possible treatment in there, but if we can help to use community corrections as EOP, I think that would be advisable.
Your Honor, did you say jail credit when you were given?
I did 53 days. Yes, Ms. Hall?
When am I able to talk to Blazak?
I don't know. I'm only in charge of me and these two people over here. Everybody else out there is on their own. So, all right, Ms. Hall,
Thank you.
good luck. Thank you.